Thank you, Nabil Hassan, for that presentation. It was very succinct, yes, yet comprehensive. In order to discuss the issues raised in the presentation, we have with us today our guest, Mr. A. Hassan Arif, former Attorney General and former Advisor of the Ministry of Law, Justice and Parliamentary Affairs, Madam Justice Kashefa Hussain, a serving judge of the High Court Division of the Bangladesh Supreme Court, Mr. M. Naser Alam, Head of Chambers of M&A Associates, specializing in corporate and commercial law, and Mr. Shadab Khan, Managing Director of Coca-Cola Bangladesh Limited. May I request the panelists to come to the stage and take their seats, please. There will be opportunities for members of the audience to ask questions to the panelists. We will try to leave some time at the end for a Q&A session. But if you have a question that you really like to ask during the middle of our discussions, please feel free to do so. Just raise your hands and we'll get someone to you. One of the issues that Mr. Nabil Hassan touched upon during his presentation was medical negligence. And I would like to begin with my questions on medical negligence. Every other day, we read in the newspapers or we encounter in one form or another botched up surgeries, administration of too much or too little anesthesia, patients being kept on life support long after they've passed away. Yet, very rarely we see that hospitals and clinics are ever held accountable. My first question will be to you, Mr. Hassan Arif. Bearing in mind the all-pervasive nature of medical negligence, why do you think that there has been so few, if any, successful compensation claims against hospitals and clinics?
Hello. Is it okay? It's okay?
Yes.
That's fine. A little while ago, we have seen in the slide the background scenario in respect of medical negligence and the response of the is it okay? I think the apathy on the part of the victim or his family to go for compensation. The first and foremost object initially is anger, and fulfilling that anger, they go for criminal action against the perpetrator. But simultaneously, the victim definitely has suffered physically, mentally, and if there is a loss of limb, then his entire life is handicapped. For that, there is no effort on the part of the victim to go for compensation. The question is why? Because there are many such situations prevailing which discourage rather than encouraging the victim to go for compensation. First of all, there is no set principles for or procedure for seeking compensation for medical negligence. And as it has been pointed out by Mr. Nabil Hassan, that since it is a specialized area, a civil court may not be in a position to assess the loss or whether there has been negligence or not. So, in the absence of such a tribunal or any forum where we can get the compensation apart from the criminal liability they suffer. For holding them against civil liability, or the civil judiciary perhaps is not adequate. And then there is a body, the disciplinary body, BMDC, Bangladesh Medical and Dental Council. The law, in fact, takes only disciplinary action against delinquent, but they have no power or no procedure for seeking application or seeking or inviting a victim for compensation. So these are the lacks which discourage a victim from seeking compensation or holding the perpetrator for civil liability. The tort may be divided into two. One is criminal liability, another is civil liability. And tort is basically civil liability. And we are still shy, as well as the whole judicial institution is still shy. We hear about the High Court division, followed by the Appellate division. Because of their judicial activism through writ jurisdiction, they have come forward. But we have not seen any action before the civil court for compensation. Only in rarest of rare cases we have seen one or two instances, but not much.
Two cases in the writ jurisdiction. Do you think the writ jurisdiction is an appropriate forum for recovery of compensation for victims of medical negligence?
For that matter, writ jurisdiction, I would not confine it only to medical negligence. I'd consider all instances of tort, whether can be obtained through the judicial review, power of judicial review of the High Court division. The Indian jurisdiction has evolved, and in fact, jurisprudence is gradually developing in the Indian jurisdiction, where Article 226 of the High Court and Article 32 of the Supreme Court of India are gradually being used, and I have seen several cases there. And lastly, similar cases were there. Say, for instance, open swearage. A child fell through it, the court granted compensation through writ jurisdiction. Then there was live high-powered cable. Then Indian Supreme Court granted compensation against Delhi Electric Supply Undertaking. Then the Calcutta High Court, in a case filed by somebody against the Calcutta University, they also granted compensation, which was upheld by the Indian Supreme Court. And the observation of the High Court in the case of, as well as in the rape case, Mr. Hassan pointed out that we cry hoarse about punishing or introducing death sentence for rape, but what about compensation? In Indian jurisdiction, we have seen that the let one. But for now, would you say that the writ jurisdiction is an appropriate forum? I would consider taking the scenario, the judicial scenario in consideration, until and unless we have some set principles or a legislation in place. I strongly believe that the High Court division, the writ jurisdiction, is a very effective and appropriate forum. Effective in this sense, as you have seen, that the beverage compensation is yet to be distributed since 1989. But this problem will not be faced and is not being faced so far as writ jurisdiction is concerned. So I consider that a jurisprudence is in its nascent form, but it can be developed, taking into consideration what is happening in and around in our neighborhood.
Madam Justice Kashefa, would you agree that writ jurisdiction could provide...
It's working, no?
would you agree that the writ jurisdiction could provide an effective forum for remedy?
Well, I partly agree that writ jurisdiction can be adequate enough, but there is a problem to it. The basic problem to writ jurisdiction, which really crossed my mind, is that the writ jurisdiction is under Article 102. There is a limitation, because unless the respondents are public authorities, belong to public authorities, it is a bit difficult to avail the jurisdiction. For instance, in medical negligence. If it's a private clinic, recently an order has been issued by the High Court Division where in writ jurisdiction a compensation has also been awarded. But then the respondents, the Ministry of Health was probably the respondent or whatever, but actually the main perpetrators of an offense, if we take it as an offense, okay, a medical negligence is an offense. The main perpetrators of be it in tort or whatever, we cannot we cannot bring them as respondents. We cannot bring private parties as respondents in writ jurisdiction. That is a big limitation in jurisdiction, and that is why there is a need to, and we have seen that our jurisprudence has not really, medical negligence is nothing new to our culture or our society, but somehow our jurisprudence has not developed like that. There has hardly been any cases, of very isolated cases against medical negligence, very isolated ones, or negligence as whole, not only medical negligence as whole. It has not developed. That's why I think codification is necessary, of a separate nature, of a special law. Just another set of special law is necessary.
We'll come to that. Regarding Mr. Nabil Hassan referred to the Consumer Rights Protection Act 2009. Yes. And in India, for instance, the consumer protection legislation provides a very popular forum, I would say, yes, for victims of medical negligence. As many as 150 to 200 cases are filed every year, medical legal cases, before the consumer tribunal also. And damages are also being awarded. Do you think that the Consumer Rights Protection Act of our country, 2009, would provide an adequate mechanism for recovery from compensation?
I am not very conversant with the Indian Consumer Rights Protection Act, but so far as our consumer protection rights are concerned, in my opinion, I really do not think it is adequate enough to protect, to bring in board the concept of medical negligence. Like our Consumers Protection Act, so far I understand, or so far what I have read, or when I have gone through the Consumers Protection Act, it is a much more broad, it covers a broader perspective of service receivers and service providers. Bhokta, যেখানে bhokta বলছে, মানে the word is bhokta. It is in Bangla, the word is bhokta. So bhokta covers a wide range of service receivers or end users or whatever one might call it. And it does not really bhokta. And the words, there was a word in section 76, I think, ponno ebong drobbo, something like that. So ponno and drobbo can hardly, that would be hyperbolic. I mean, if we can call it a hyperbole, that would be too far-fetched to stretch it to medical negligence. The Consumer Protection Act, I do not find any of the sections of the Consumer Protection Act which can be directly applicable to medical negligence.
Ms. Naser, you've worked with the Consumer Rights Protection Act. You've some experience of working with the Directorate of Consumer Rights Protection Directorate. So would you say that this law may be useful in providing compensation to victims of medical negligence?
Thank you so much. We have to first understand how we are defining medical negligence in what sense, and the scope of Consumer Protection Act. As Madam Justice has correctly pointed out, the scope of Consumer Protection Act is very limited. However, considering that there is no substantive law directing a victim of a negligent injury to go to a particular forum. Therefore, many of the victims are resorting to the last point, which is the DNCRP, Directorate of National Consumer Protection. I dealt with a medical negligence case, very high-profile case before DNCRP. What I found, the DNCRP is actually not a forum for recovery of compensation per se for tortious injuries. There are a lot of limitations there. If you see that the director has power under Section 21 to take proyojonio babostha, necessary action, but nowhere in the Act it has been defined what would constitute a necessary action. If DNCRP needs to give a remedy in the form of compensation, DNCRP itself, the director itself, or the directorate itself, then it has to know what kind of authority do I have to issue compensation. DNCRP has per se very limited right to issue monetary compensation. If you analyze the scope of the Act, you'll see that DNCRP's main role is taking a complaint, acting as an investigating agency in some form. For example, if you look at section, I forgot the section name, where in relation to adulteration of medicine, DNCRP only has the right to investigate and make a report and not to file a criminal case. Right? So, if, as I say, that medical negligence, the term should be very clearly defined, is adulterating my drug also, does it constitute a negligence? Medical negligence, does it mean that I have to literally go to a hospital, either government or private hospital, and because of their negligence, I have suffered some damages? So we have to understand the right scope of the term medical negligence. In my view, the Consumer Protection Act fails to define the term, and therefore, any remedy, even the limited remedy available under the DNCRP jurisdiction, is very limited. Number two, if I may, if you look at section 52 and 53 of DNCRP, it says 3 months, 2 lakh, 3 months, 2 lakh, 3 years, 2 lakh taka, 3 years jail, or maximum 2 years, 2 lakh taka compensation. So the limit compensation is very limited. If you look at section 66, which says that if you are instituting a criminal complaint, means DNCRP is instituting criminal complaint on your behalf, on the victim's behalf, you cannot directly go to the civil court. If you want to use the Consumer Protection Act, if you want to use it, you cannot directly go first to the civil court and seek compensation. In section 66, it says serious inhibition for any victim to go directly to a civil court and file a compensation remedy. Once you have filed it, you cannot come to DNCRP. There are some legal challenges. So therefore, I think there is some remedy available there, but it's not going to be in the nature of getting a fair, adequate, reasonable compensation for the victims of medical negligence. Thank you.
Mr. Hassan, the precursor of this law, was the Uttarakhand 2008, and you were the advisor of the Ministry of Law at the relevant time when the Uttarakhand was enacted. So, what was the intention of the lawmaker? Did you envisage that this law may be used for recovery of compensation on behalf of victims of medical negligence?
Thank you, Siddiq, for pointing out that initially the law was initiated in 2008 as an ordinance. And the main object of the law was to protect the consumer. And the very term consumer distinguishes the person receiving medical treatment and a person buying some products. Though service is there, is also one of the product, but that service is mainly relating to some form of consumption. So initially, the object was to protect the consumer, as you know the background history, because for quite long time there was agitation, there was demand from the public sector, there was a body also in order to protect, highlight or agitate the sufferings of the consumer, particularly keeping in mind the adulteration of the food and such things. So medical negligence was not perhaps in mind while making this law. The main stakeholder was the consumer and what that consumer means.
Madam, this is Kashefa Hussain. In light of what we have heard, do you think that the interests of victims of medical negligence would be better served if there was a special law, a special forum for dealing with these cases?
Yes. First, before going on to that, I would just like to echo what Mr. Hassan Arif, my senior Mr. Hassan Arif had just stated, that this is what I had, that the legislators, that what I had in mind when I was reading the Consumers Protection Act. This is what I had in mind, that the legislators probably did not have the medical negligence perspective in mind, and this is what Mr. Hassan Arif has has affirmed. The legislator, as he was then part of the legislature, has thus just affirmed. So now the question is that what was the question, if you say?
Yeah. Would the interests of the victims be better served if there was a special
yes,
law and a special
that is
forum?
what I was coming to. In medical negligence, excepting for there are some provisions in the penal code, it is probably I have to see this, the relevant sections. Sections 304A, Section 336, Section 337, Section 338. Not directly, though they are not even those sections, those relevant provisions, those sections in the penal code, they do not, and nowhere in the penal code is it. They do not state the term medical is not stated. It is negligence. Again, this is a broad perspective. And then we have this the medical dental and medical Counsel Act, and there is something else. But those are basically, when I went through those laws, they are basically guidelines, and one of them is just as what a doctor should do or should not do. It is more or less ethics. They are guidelines on more or less ethics, but they are not constituting a procedure as to what happens in case of medical negligence. What happens when a medical negligence occurs, in whatever form. Medical negligence is a very broad term, and it can occur in many stages, in many ways, by doctors, by the administrative committee in any clinics or hospitals, by nurses. It can occur in any forms. So I think it is high time, and medical negligence has escalated, as we know, with the social conditions, and it is, I guess, a reflection of medical, as anywhere offences have escalated. It is an offence, and a doctor, it is a negligence, we can call it an offence, because a negligence is an offence by itself. It is a criminal offence, because he is conscious. When a doctor is performing, he is conscious of his duty. So it is a very thin line between between what is criminal negligence and what is not. So I think it is time for codification. We need a direct codification. We need a special tribunal. We were just referring somebody to this tribunal in the US. If necessary, the legislators can scrutinize those laws or compare them with laws of other countries. And I think it is time that we enacted a specific code where the doctors or the hospitals or the management of the hospitals, whoever, should be held responsible, and we need proper an exhaustive procedure. The facts and circumstances of medical negligence cannot be made exhaustive. It will depend on the facts of the case. But the procedure itself that will determine through evidence, through witnesses, through documentation, has to be more or less an exhaustive code. And another thing I wanted to say is that it should be, would serve the purposes, it should be somewhere, the procedure should be of a quasi-civil and quasi-criminal nature. It cannot be completely criminal or completely civil. So the procedure has to be enacted accordingly.
Thank you.
Special law.
Mr.
Thank
Shadab,
you.
You are a consumer industry expert, and it appears from the discussion that the Consumer Rights Protection Act was designed for your industry. So how useful do you think this act has been in recovering compensation on behalf of consumers?
So first, like Mr. Arif pointed out, yes, it was, clearly has been the case where it was meant to protect consumers against adulterated food, to be specific. And this is where I first want to start making that distinction. And as multinational operators in this country, one of the larger challenges has always been for us that things that happen in one market are not necessarily restricted to one market. They traverse across fairly very quickly, and therefore product quality, product processes, quality standards that most multinationals follow are ensuring global guidelines. The challenge really was, and I believe, and with a lot of the local startups that have happened, and I've seen a lot of improvement in the local organizations from a compliance standpoint. Not all, not as much as I guess it should be, but clearly that focus on the fact that there can be remedial actions the consumer can seek has pushed at least some of the compliant large organizations in the consumer space to do more and to do better. I think one piece that has really helped is the whole quasi piece that through the directorate that has happened. The 25% fee, the 25% of the fine that consumers can take away in case of a award has really helped also to bring more and more such complaints out. Unfortunately, again, from a manufacturer standpoint, I see that as also a challenge because there's a lot of frivolous complaints. There's a lot of just for the sake of making that money that I'll go out and do that. But in my mind, it is still a good thing to do because that helps build education and awareness and knowledge of what the consumer right is. And I think at a much larger level, even for the, even in the case of tort, for example, for a country the size of Bangladesh, the number of torts that we should be having, you're nowhere close. And therefore, even with all of the consumer complaints that are coming through, I still believe the much larger challenge is for the industry overall to continue to build on consumer education on this one.
Are you aware of any successful compensation claims that have been made under this act against any big MNCs, for instance?
Unfortunately, most of these compensations that I'm aware of are very, very small. The only one that I remember outside of, but I just realized that it hasn't been paid, Bengal Beverages versus this one. The other, if I remember right, again took 30 years, if I remember, that adulterated saline, some pharmaceutical company, but that took 30 years as well. From a product liability standpoint, I think the largest challenge is the process, meaning I think it is so slow that for a consumer to go through that 30-year or 20-year journey where they will probably not even recover the legal fees at the end of it all, and then having gone through all of the trouble is probably not worth it. So therefore, one, the number of actual cases are low, and even when that has happened, it's more for the quick buck rather than really taking a manufacturer to task for a shoddy product. And therefore, I am not aware of any successful compensation claims around this.
But do you think that if the procedure were made simpler, quicker, that there would be more compensation claims under this act? Because we've heard the Hussain in the bottom case the Tort University, which is the foundation of the modern law of negligence. And consumers in Bangladesh, I think we have come across lizard tails in soft drink bottles. It's not very uncommon. But why don't these tail in the bottle cases, we call them, ever make it to court? Why don't they culminate in compensation claims? Is it just because of the procedure?
So no, one largely because that is manufacturing-wise impossible to happen. So a lot of those tail in the bottle are completely fabricated. Most of them are largely fabricated. Some things are possible from a manufacturing standpoint, and I have to put my hand on my heart and say, is it while we are 99.999 sigma % safe in everything that you do, is there a possibility of something going wrong? Absolutely. And that is where, as organizations, we are saying we need to be ready to ensure, across the world that you deliver the same product to the consumer. And in my mind, the current 2009 Act is still very young from a consumer acts protection standpoint. And through the directorate mechanism and through the quasi-judicial process that I say, I think it's already very, very quick. So therefore, awareness and information dissemination and ensuring more consumers are aware of their rights is probably more important rather than a tweak in the process itself. Because I believe the current process that Bangladesh has could be a model for the subcontinent and really a best practice model that other countries could evaluate as well. So it's not speed, it's awareness that I think will be a bigger opportunity here. Awareness about the fact that you can, if something goes wrong, that you can actually take the manufacturer to court and get a compensation around it.
Thank you so much. I think I'll go back to the question whether we need a separate legislation or substantive law for tortious claims. We have a very old law, Fatal Accidents Act, I think in around 1855 or something. And that gives a very basic, a very fundamental tool. I don't know whether it has been tested in the courts in Bangladesh. I think the audience needs to understand. They are also trying to understand, being lawyers, where if a claimant goes to them, which tool they are going to use. By tool, I mean which law they are going to use. In the high courts, we have seen the Catherine Masood's case, the motor vehicle ordinance has been used. I'm surprised, why not the Fatal Accidents Act? Because the Fatal Accidents Act provides squarely the death. It only applies to death, not other form of injury. Why it has not been used, we really don't know. And from reading the judgment, I also don't find why it has not been discussed even by the honorable justices. Secondly, we will definitely come to the motor vehicle ordinance later on. We have the Consumer Protection Act as a fundamental tool. We also have the other laws, if I may say, the Private Clinics and Laboratories Ordinance. It's very procedural. It's delisting the fraudulent medical conduct, but can you then use the writ jurisdiction? I'm going back to the substantive law point again. Can you then, on the basis of finding by a tribunal or by let's say the DNCRP that they are liable, can you then go to the civil court or any other forum to impose liability in the form of a civil nature liability on the perpetrators of negligence? So we have a lot of laws which squarely does not cover, but we need to have a consolidation. I think right now what we need, I always refer that in UK, why the system is the social system is running very smoothly is because no one can interfere with your rights unduly. Criminal liability has its different form, but it really hurts you when your money is taken from your pocket. If I tell all the audience to give me 5,000 taka now, they will really become unconscious, some of them, right? Because it hurts. In China, they have a policy. In work level also, they have a policy that if you're late for 5 minutes, okay, you're late, you have to give a penalty. So this financial compensation regime to make it stronger, we need to have a consolidated law. We have Fatal Accidents Act, we have Motor Vehicles Ordinance, we have the DNCRP's Consumer Protection Act, we have other acts and ordinances. We have also the penal code, but the compensation is also there. The penalty is there, but the penalty does not reach the victim. So that's what I want to add. Thank you.
Thank you. One of the issues that was touched upon during the presentation was workplace harassment and bullying. And Mr. Nabil also referred to the directives of the High Court Division regarding prevention of sexual harassment in the workplace. Now, Mr. Hassan, do you think that we can press the law of tort into action for recovery of compensation by victims of sexual harassment against their employers?
I do think so, that for harassment, you have a suffering on the part of the victim. Her agony, humiliation, stigma, etc., as well as it may lead to her unwillingness to continue with the work, so loss of livelihood. So the harassment has all the elements of victimizing the victim. So I see there why it shouldn't be also an event or incident for suing the person, perpetrator, for sexually harassing her. The extreme form of harassment, if I am permitted to say so, is violating the women. So if that is now taken as a compensation incident, this harassment, in whatever form it may be and whatever degree it may be, can be taken to court for compensation. There are guidelines, no doubt, to be put in place in workplaces and educational institutions. We haven't have any data as of now that how many corporate bodies, big or small, private limited companies, whatever small form of business concern, educational institutions have this guideline put into place. There is no survey, no data as well. It has been reported that when it is brought to the notice of the organizations that do you have this committee or body in place, their response is ignorance about the judgment of the High Court Division. So this shows that there is a communication gap, that only those who are concerned or those who are aware of what is happening in the High Court Division, even I believe that not all the lawyers who are not particularly interested in this area of public interest litigation may not be aware of this judgment even. So that shows that, as Mr. Shadab Khan has said, that awareness is an area where we are very much shy, and public are not aware of, or the organizations are not aware what is to be done so far as making the public place, making the place of work safe for the women and children.
Mr. Shadab Khan, to what extent have the High Court's directives been implemented in the consumer goods industry regarding prevention of sexual harassment?
Again, since I am part of both the Foreign Investors Chamber and the American Chamber, and on behalf of pretty much most multinational companies, I can say that it's been implemented not just in letter but also in spirit. Because for most of us, going back to what I was saying earlier, the implications of this are global. Therefore, whether it is Coca-Cola Bangladesh, our bottling entity here, International Beverages, we have ensured that not just here but globally as well, we have a safe workplace policy. And for us, discrimination or harassment is not necessarily, does not necessarily stop at sexual. It is, racial profiling, discrimination on rights of, worker rights. There are a whole lot of aspects that for us go into harassment itself, because for us it's an open workplace policy that we have, and any form of harassment, whether it is sexual in nature or otherwise, is equally serious. More specific to the High Court directive itself, we have a functioning committee in place. We have inducted 2 female lawyers from our associate Tanjeeb Alam's office into that to ensure. And like I was telling you just before the start of the session, the big piece is also senior management focus and attention to these things. You have to set a culture saying this is not okay, that this is not acceptable, and we have taken extremely strict action even as early as last month against an internal colleague, who we found was not, living up to the values of the organization. So unless you have that larger philosophy in place and push that down fairly strongly within the system, so that's what I would say. Meaning.
Thank you, Madam Justice Kashefa. Just one last question before we go to the Q&A session. Do you think that these directives are enough, or do you think that there is a need for specific legislation to ensure corporate accountability? We'll go to Q&A session right after this.
It is encouraging to know what Mr. Shadab Khan just said, that these the High Court directives from the BNWA cases are kind of being implemented by, or are being implemented or are they being complied with by the corporate sector. But my anxiety arises from the fact that what Mr. Shadab Khan is referring to are big companies, corporate sectors, which are large corporate entities. But what about the small companies? Even a company can be formed by 4 members. There can be 1 director and 1 MD, and maybe there is 1 employee. I'm just talking hypothetically. There could be one female employee, and the company could be constituted by 2 directors or 1 chairman, whatever. Then what happens then? Is there a departmental proceeding is not possible then? It is too small. There are financial feasibilities. For a big company, these are easier. But what about the financial feasibilities? What happens then in a small company? Supposing the employer himself, not the supervisor, not a second person, but this employer himself is the perpetrator. What happens then in the context of small companies? That is why, as in medical negligence, my proposition is that we need a uniform codification which will be applicable to all companies, all corporate entities, big or small, where there will be a procedure to ascertain and determine whether sexual harassment took place or not, whether there was an harassment at all. There could, hypothetically, there could be, it could be a misnomer by itself. Maybe an harassment did not take place. It could be a counter allegation. There could be counter allegations. So these things, so bring these into board, to bring all kinds of companies into board, there has to be a uniform codification.
Thank you very much. We'll now get to the Q&A session. So if there are any questions, Mr. Khalid Chaudhary, please.
World of academia. I've taught English law for 24 years. Obviously, the discussion makes it very clear that the constitutional tort is actually a necessity, has become a necessity by pressure, I would say, because as Madam Justice have rightly pointed out in my humble submission, that Article 102 is limited. How can you award compensation by simply issuing a rule? Because generally, as we know, in any application for judicial review, you have to seek some other remedy, some other declaration, prerogative remedies. Along with that, there can be a claim for compensation. But directly calling people up, of course, that's a need for time, because the lower courts are failing because of the complexity problems with access to justice, delay. We have just seen from Nabil's lecture presentation that there was a suit filed in 2004, it's still pending, right? And only those with power, only those who have with the perseverance and I would say the commitment can stick to courts and stay for 15, 20 years to get some compensation. So my one observation is I'm also an arbitrator and mediator, right? Why not we talk of mediation in tort cases? Of course, we need legislation, we need other options, we need to have a proper mindset of the lower court judges, more education, more seminars like this. But mediation in tort cases have been effective in many jurisdictions. And we have an ADR culture being developed with millions of cases being pending by 2020, right? So mediation is inexpensive. It can be a court-based mediation. And sometimes we might have some more forums to encourage parties to come for voluntary settlement with the help of qualified mediators.
So why not mediation?
It's a novel idea, no doubt, but taking into account the nature of the act, I wouldn't say offense, and the social context, the perpetrator are generally very recalcitrant to surrender to court, so forget about surrendering before the mediation. These are social contexts that we have to take into account. And first of all, on the part of the victim, judiciary is a set forum. It is acceptable to all. There may be camera trial, but they may feel reluctant to share their agony, share their trauma with a gentleman who is not coming from the judiciary, a set forum. And notwithstanding the fact that judicial review may have limitations, as we think now, but mind it, judicial review is a developing jurisprudence. In one area it has developed, it has reached its finer areas, but in other areas also it is developing. Could you think of public interest litigation before Muhyiddin Farooq? No. That means, and look at India, I was just going through some of the cases from Indian jurisdiction. As I said, even in rape cases, the court granted compensation by the High Court division, by the High Court, affirmed by the Indian Supreme Court. Then, few words, I think, I feel tempted to say like this, that a lady was victimized by employees of railway, maintained by the central government. Supreme Court upheld award of compensation by the High Court under Article 226. Remedy under 226 being a public law remedy for violation of fundamental right, enforcement of public duty, notwithstanding suit could be filed for damages under private law. So this takes care of the scare of alternative remedy. Though it is not a hindrance on the part of the exercise of jurisdiction, but we find sometime the judges are reluctant only because of that, as if it's a jurisdictional embargo. It is not. So anyway, I have a great faith in power of judicial review, and the judiciary, the jurisprudence that is being developed in and around, even Lord Diplock. Who doesn't know Lord Diplock? He has also developed this proposition that yes, you can get compensation for violation of their fundamental right. And my dignity, my honor is my fundamental right. My reputation is my fundamental right. So I come to High Court for judicial review under the umbrella of my fundamental right. So it depends on how you formulate your claim, formulate your demand. High Court is the forum, and the rest is procedure. So we can reconcile, and that is why I have great faith in power of judicial review is an adequate remedy in the absence of course, in the absence of the situation that we have. Until and unless that is done, the victim cannot just cry here and there. They have to have a forum, and I feel that High Court Division is a forum, or judicial review is a forum, an effective forum for compensation.
Mr. Hassan, could you just add, if you'd like to add anything, under 1 minute. Sure. We're out of
Thank you. I think, let me refer to Justice Bhagavati in one of the case, Khatri's case, that we should innovate. In many other jurisdictions, which are very mature jurisdictions, in UK, in Netherlands, in US, it's been used even in tortious claims. For example, we need to have multiple institutions to deal with tort claims, because some of the tort claims are not, it's not unipolar. Medical negligence is a different kind, sexual harassment is a different kind, motor vehicle incidents are different kind. So, like in the Tariq Masood case, it started with a tribunal's referral to a tribunal under the motor vehicle ordinance, and then it came to the High Court. So maybe, I quite agree with you, sir, but I think there are options or there are opportunities in future to go to mediation to settle some of the disputes. In fact, I was involved in resolving a tort claim through mediation. It went to DNCRP in another claim. It went to DNCRP. We managed to talk to the victim, and then it was settled out of court through mediation by appointing an independent mediator. We innovated it. So I'm sure there is scope, but you are correct that for the time being, considering our legal regime now, judicial review is perhaps now giving us more insight than others. Thank you.